And then this is the only one I put the drink down here because they didn't have a little extra table. So that's okay.
Okay, sure.
Yes, those are working.
She's a Georgetown fellow.
And I love our husband too.
Oh, he's a sweetheart.
Can you scoop that?
I'll sneak through without knocking over your.
Okay,
Oh,
perfect.
sorry.
I hope.
You good? There we go.
What's that?
You get to hang out with the kids.
So I
Oh
think,
my God,
yeah.
this is why I'm
You're
here.
outside now.
It's pretty unusual.
Guys, I would not have.
I know. Watch out. Open mic time. She's the pro. She's giving us all the tips.
It's pretty unusual.
Hello, everyone.
Morning, men and unpaneled.
Good evening. Thank you all for joining us. I'm Aslihan Bulut, and I have the honor of serving as the Law Librarian of Congress. Welcome to the Library of Congress, and for coming to Center Court Sandra Day O'Connor and the Supreme Court, a commemoration of the first woman Supreme Court Justice and her career. Today's event is co-sponsored by the Supreme Court Historical Society, and I'd like to thank them for joining the library in sponsoring today's panel. Also, many thanks to the panelists for coming this evening to discuss Justice O'Connor in all her complexity. With the Law Library's legal holdings and the Manuscript Division's collections pertaining to the law, including the papers of district and appellate court judges, Supreme Court justices, and jurists working in the nation's lower federal courts, as well as its highest tribunal, we believe the Library of Congress to be, if not the premier, one of the premier institutions for legal research. Therefore, few spaces would be as appropriate as today's panel than the Montpelier room here in the Madison Building, home to the Law Library and the Manuscript Division, which we hope you'll visit. Before we get started, I want to introduce the Executive Director of the Supreme Court Historical Society, James Duff, who would like to say a few words. Thank you.
Thank you very much, Aslihan, for including us. It's an honor to be here tonight, this evening, for the Supreme Court Historical Society to co-sponsor this grand event to commemorate Justice Sandra Day O'Connor and her career. It's especially a pleasure for us to be here partnering with the Library of Congress on such an event. We're also grateful to panelist Ted Olson, who is a dear friend, and his participation today is much appreciated. He served on our board of trustees for many years. A little over 12 years ago, the Society hosted a celebration of the 30th anniversary of Justice O'Connor's appointment to the court. The celebration was held at the museum and was a discussion with Justice O'Connor and the three other sitting justices, women justices on the court at the time, Justices Ginsburg, Sotomayor, and Kagan. It was the first time all four had appeared together for such an event. I was the CEO at the museum at the time and moderated that discussion. And I wanted to share with you just one brief comment Justice O'Connor made during our discussion that evening. You can see the entire discussion on YouTube. She said, you know, it's all right to be the first to do something, but I didn't want to be the last on the Supreme Court. If I took the job and did a lousy job, it would take a long time to get another one. So I was very nervous about it. Well, I think we can all agree that Justice O'Connor can rest in peace. She did an outstanding job on the court and paved the way for other outstanding women to serve on the court. She was also a trailblazer for civic education while in retirement from the bench. And she's been an inspiration for new initiatives that the Supreme Court Historical Society has undertaken in that field. Ryan Reft is going to kick off this evening's program. Ryan is an historian of the modern United States with a focus on domestic policy and politics in the Manuscript Division here at the Library of Congress. and his many responsibilities include overseeing collections pertaining to the law, Congress, and journalism. Ryan?
Thank you, Aslan. Thank you, James, for being here. Thank you, our distinguished panel, for being here. I'd also just like to remind everyone that if you didn't get to see the display beforehand, it will be open from 6:30 to 7 after the event. I'd also like to thank development for helping us out here, both financially and with organization. I'd like to thank my division chief, Janice Ruth, and head of acquisitions outreach, Bridget Burke, for their support. And of course, Laura Kells, senior archive specialist, who is working and also, of course, my traditional partner in crime, Connie Cartledge, who you may have met over there. I would just say that if you have a chance to chat her up, you should, because Connie is the nation's leading legal archivist, has processed over almost half a dozen Supreme Court papers, judges, jurists, Robert Bork included. Possibly no one else knows more about the court and the lower courts than Connie Cartledge. So a privilege to work with her all these years. With that said, almost 35 years ago in 1990, Justice O'Connor was gracious enough to donate her papers to the Library of Congress. In the following, from 1991 to 2008, she made additional installments, and her papers joined 3 dozen justices and chief justices from the Supreme Court that we have and are honored to have under our stewardship. That includes names like John Marshall, Thurgood Marshall, no relation. Also, guess who processed Thurgood Marshall? Connie Cartledge. Earl Warren, of course, Harry Blackmun, processed by Connie Cartledge. William J. Brennan, RBG, Connie again. John Paul Stevens, Connie again. And Sandra Day O'Connor, Connie again. So you see what I'm getting at. Justice O'Connor served for over 2 decades on the court, played a critical role in countless decisions on issues from free speech, reproductive rights, affirmative action, voting rights, and many others. Her vote on the court became one, if not the most, sought-after vote by jurists across the ideological spectrum. As her papers attest, her jurisprudence and her ability to form coalitions among her fellow justices often influenced the course of the court during her 25 years on the bench. Yet her legacy is not limited to oral arguments, conference room debates, and opinion writing. It extends symbolically and practically. As James was discussing so generously, as the first female justice, she experienced a remarkable opportunity, but one that carried an undeniable burden. Being the first always comes with the yoke of expectation, often unreasonably so. Rightly or wrongly, fail to meet the expectation, you might hinder those that come after you. While Justice O'Connor clearly understood this dynamic, it never seemed to stress her, and if it did, it was never apparent. In the age of analytics, the numbers testify to her grace and judicial talent. She opened the door on the court for women in 1981, and since then, the court has quadrupled that number such that women now make up over 1/3 of the court. With this in mind, I would welcome you and our distinguished panel that I promise will dig into all the above, and I'm going to just briefly introduce all our panelists now, and we'll kick this off. Kimberly Atkins-Storr, our distinguished moderator, senior opinion writer at the Boston Globe, co-host of Sisters in Law podcast, recommend you check that out, as well as the new podcast, Justice by Design. Judge Naomi Rao, United States Court of Appeals for the District of Columbia Circuit and former clerk to Clarence Thomas in 2001-2002. Julie Rose O'Sullivan, Agnes Williams, I cannot say this word, sesquicentennial professor at Georgetown Law School and former clerk to Justice Sandra Day O'Connor, 1985-86. Joan Biskubic, pardon me, fellow Chicagoan and CNN senior Supreme Court analyst and author of Sandra Day O'Connor, How the First Woman on the Supreme Court Became Its Most Influential Justice. And last but certainly not least, Theodore Olson, partner Gibson, Dunn and Crutcher, LLP, and former Solicitor General of the United States, 2001-2004. Thank you for being here, and let's get it started.
Thank you so much, Ryan. It's such an honor to be here to moderate this really great conversation about Justice Sandra Day O'Connor. I was 18 years old when I got to meet Sandra Day O'Connor when I came to Washington, D.C. for summer. And part of that involved going with other students to the U.S. Supreme Court, and she was there and was so gracious to talk to us. I was thinking about going to law school. I thought that that might be where I might go. And after speaking to her and telling us, among other things, about how the fact that she was a cattle rancher and she was just taught to do things and not to let things stop you and don't expect anyone else to do it for you was one of the inspirations that said, yep, I want to go to law school. So I am grateful for her for helping put me on the path that I went on. So this is such an honor. And I want to start off our discussion from people who understand how she ticks better than just about anybody else, talking about her unusual background. These days, every justice of the Supreme Court, they usually come from an appellate court. It's usually the DC Circuit. It's, you know, they go up, they're from Ivy League schools. Sandra Day O'Connor was a cattle rancher from Arizona. She was an elected official. She couldn't get hired at law firms after she graduated law school, so she had to, by necessity, pave a different path. So I want to get an idea about how that shaped how she came to the job. Julia, you clerked for her. I'll start with you.
Well, I do remember her brother came to visit, and he looked like a rancher. Big belt buckle, hat, the whole thing. And I asked him, how many cows do you have? Apparently, that was a complete and utter no-no. That's like asking somebody, how much money do you make? And I didn't understand, but Justice O'Connor's context was so different from a girl from New Jersey, right? Like at some point, I understood that it was different. Where I really saw it was her time in the legislature, I think, really affected how she operated as a judge. Not because she was overtly political, because she actually wasn't, but because she believed in bringing people together, usually over food, to actually talk about problems, to actually think about it. You may continue to disagree, but she was a big believer in actually having conversations and having relationships that mattered. And that's one of the reasons I think she was the fifth vote in so many things, because she really understood the court and the people on the court and how to position herself, not politically in the bad political sense, but in the sense of how to make things work.
Yeah, Ted, talk about that. Do you see the difference in her background, having advocated before the court and spoken to her? Do you see that affecting her jurisprudence or just how she approached having the job?
Well, there's a lot of things to say, and I can't tell you how much I appreciate the opportunity to talk with others about Justice O'Connor. She was fantastic, and her not just her background, but her tenure on the court, her relationship with her colleagues on the court, her relationship with those of us who argued before her. She was amazing. Well, she was not just a cattle rancher, and I don't mean that as just, but she served in the executive branch in Arizona. After she went to law school, she worked a little bit as a legal secretary. She served in the legislature. And she served in the judiciary in Arizona. So she'd served in all branches of government in the state government. She's the last person on the Supreme Court to have held political office, to hold elective office. If you read about her own material and in Joan's material and so forth, you know she was a person, that background on the ranch, which was a big, huge place. You know how many thousands of acres that was, made her, and the way her family brought her up, she was someone who was going to get things done. And when she worked in the legislature, she brought those guys together, and they were mostly men, and they mostly hard drinkers in the legislature, and she knew how to bring them together, and she did the same thing on the court. She was highly respected, but she brought people together. One of the reasons why she was such an instrumental vote on the Supreme Court is that she brought her colleagues together. She had a finely tuned sense of common sense and the real world. She always cared about the facts. She always found a way to bring her colleagues together to come up together on opinions. It wasn't an accident that she was sort of a key vote in the court. She made herself a key vote in the court by talking to her colleagues and bringing them together and producing opinions. And I could go on and on about what it was like to argue in front of her, but I know you want to hear from other people on the panel. She was a remarkable person. She was brilliant, but she was efficient, and she was a taskmaster. She told her colleagues, we were on a panel a few years ago at the Library of Congress, and Justice Ginsburg was saying when she was just appointed to the court and she was assigned the first opinion, and usually it's only fair when a new justice comes on the court to get something 9-0, easy case, bankruptcy or something. Not to say that that's easy, but something that they can write an opinion that everybody will agree with. And Justice Ginsburg was agonizing over this because she'd been assigned something that was really a lot harder, and she was trying to figure out how to get it done. And she went to Justice O'Connor, her senior sister on the court, and Justice O'Connor said, "Ruth, just do it."
Judge Rao, tell us a little bit about what she was like behind the scenes in terms of having that different background and working with the other justices and not being intimidated by the fact that she was the first woman on this court full of 8 men.
I mean, I guess I saw it sort of, I was in a different chambers, but, one of the things that it seems to me that Justice O'Connor's background accounted in part for her very pragmatic approach to cases. She was concerned about the real world consequences of things, and I think some of her experiences in the real world affected her jurisprudential outlook that way. Another thing that I observed, even from these other chambers, is just how independent-minded she was, which I greatly appreciated. Talking to her clerks, there was never any sense that they could influence Justice O'Connor.
Give her a push.
There was, there'd be discussion, and we would say like, wow, Justice O'Connor's, this is really what she thinks about this case. And they're like, we disagree, or, and I appreciated that because I also clerked for a boss who was like that, Justice Thomas, who very much, there was no question about who was making decisions in chambers. And I think Justice O'Connor really carried that independence with her, which is such an important part, I think, of being a good judge. She decided the cases by her own lights in the way she thought was best, and she did it with confidence and independence in a way that was a great model, I think.
So one thing I neglected to say at the beginning is we will save time at the end for questions. So if questions come to mind, sort of keep them, and we will come back a little bit later to allow you to do that. So Joan, you are a biographer of the justice, and so you have spent time talking to her. You have spent time poring over you probably already saw these papers and already went over them before we got here. And in trying to understand how she brought that personal background to her work to be both independent, but also a consensus builder, right? And so there's probably no better example than the Bush v. Gore decision. Can you tell us about how she approached that and the role she played in that unsigned opinion?
Sure. First, I want to thank the library because this is like a second home to me. I really have gone through so many of the papers here that relate to Justice O'Connor and to any contemporary justice you have. I've gone through those files, and I even came early today to go through some more. And I just want to tell you what I observed of Justice O'Connor through her papers here and with some of her colleagues that are both here and down in the Lewis Powell archives, who she was a very good friend of. So she would confide in him in ways that she didn't confide in the other justices. And then I also went through her papers in Arizona, her legislative files there. And everything that is being said about Justice O'Connor and what a magnificent American she became is all true. But she started out in a way that was very humble with missteps. And through looking through all her correspondence, all she did as a legislator and as she came up here, you could see that she was constantly learning to sort of be the leader she became. She, she started as a junior state senator. She came up here as a junior justice, of course. So there would be stumbles along the way, and she got over things so fast. And I really chalked that up to her experience with her father, Harry Day, on the ranch, that he was such a tough taskmaster that William Brennan couldn't hold a candle to him, that she gets up here and she's able to best Bill Brennan at his own game. And he was such a great strategist as a justice, always being able to pull 5 votes out of a hat. And what first got me interested in writing a biography of Justice O'Connor was finding right here in the Marshall Papers back in 1993 a note between Bill Brennan and Thurgood Marshall, where Brennan was explaining why he wasn't going to vote with Thurgood Marshall on a very important criminal law case. And he said, "I'd be with you, pal, but Sandra forced my hand by threatening to lead the revolution." And what I really felt like I saw from watching her is this young state senator, and then through, as Ted said, her experience on 2 different state courts in Arizona and then coming up here, that she really knew how to maneuver. And she just kept learning. She never thought she never had, she never was filled with hubris. She remained humble. And I think that's, to get to your question about Bush v. Gore, from everything she said, she didn't want to have to take that case. She certainly didn't want to have to see Ted there arguing before her on such an important case that then was so consequential, because I think she knew that it was such a tough one for the entire court. But she got out ahead of things. She got out ahead of that case working with Chief Justice William Rehnquist. And I found that, like in Bush v. Gore and in other cases, she would often go individually to colleagues and say, if we do this now, then it will make it easier when we work as a group. And I think that was kind of a little bit of her legislative MO. But finally, the one thing she did was that I think is so important in any kind of group dynamic: no one walked away from the table feeling like they got shortchanged. She made sure that people felt like that they got something here, even if they might not quite have. But that was her. She just had that kind of. She understood where everybody was seated, and that you had to make them feel that they were not going to be diminished in some way by the negotiations.
So I want Ted to jump in this conversation too. Of course, everyone can feel free to jump in, but I just want to, because right now I think a lot of people, I know for a fact that from my inbox that I get, is that a lot of people in the American public think that the justices come to cases with their minds made up, with their ideologies intact, and they know what the outcome is going to be before they start. That was not at all what happened in Bush v. Gore. So can you explain a little bit more about how that all went down? And I definitely want to hear from Ted too.
Sure. Well, it came up in 2 different phases, of course. And at first they worked on trying to be unanimous, and they were, to send it back to, in the version that was called Palm Beach County. But then it came back, and just so everyone, there are enough people out here who look like they have plenty of seniority to remember what happened in those few days in December of 2000.
The hanging chads, the butterfly ballots.
And Ted, I know exactly where I was in the car racing to the Supreme Court when they issued the order stopping the vote counts on that Saturday. I'm sure you knew exactly where you were. We all know where exactly, we're all of enough of an age that we remember every single thing up to the moment right around 10 p.m. on December 12th when they finally issued this. And, she, by that point, she obviously went on in 1981. She was a real leader with Rehnquist in trying to figure out how to do this and how to, her feeling was she did not want the court, working with Justice Kennedy, to go as far as the then Chief Justice Rehnquist wanted to go. And they tried to minimize what they did, but still, rule in favor of stopping those vote counts and trying to say, okay, this should be over. We're up against it December 12th. That was the electoral count deadline that they were facing that day, and there they were, 2 hours short. But what you see in her what you see in her files from Bush v. Gore, and you see in your files from just about every case, goes to what Kimberly just said of her going to a case and sort of working it out as she went along. Her notes from conference are, I think, the best notes from conference of any justice we have right now in the records downstairs. And so you see her going in with, the thoughts she would have, and Julie probably remembers this too. She'd write on a yellow legal pad just exactly what she was going to say at conference and how it would work through. And, It was hard, and I think she felt, and I think, Ted, I don't know if you would agree that in the end, I think she had enough misgivings that we did see a little bit of a change in some of her votes.
Oh, I
after
think
that,
she regretted that vote.
where she inched to the left. I guess you
Yeah.
would know. Yeah.
Well, I mean, I agree that you couldn't move her significantly, but maybe I was 5 years in, so 1986. So what I valued is she always hired a liberal clerk, a conservative clerk, and what we used to call two squishes. People in between. And she would listen to all of us. She would make us all read each other's bench briefs. And then Saturday morning, she would make lunch, which was usually some horrible taco thing. No offense. And then we'd fight about the cases all day long. And she listened to this 26-year-old who knew nothing, just stay on her, I was liberal clerk, about issues until she finally shut you down. But she certainly listened a lot longer than I would have. And so she was open, even if she wasn't, I mean, she wanted to hear it, even if she wasn't that movable. And she did significantly evolve over time. She changed her views on, the sodomy case was my term. She changed her views on affirmative action, abortion. I think she was moving
get to
on
those.
the death penalty. I mean, she really did change over time, and I think that's a recognition that she said, and she had a pillow on her couch that said, "Maybe in error, never in doubt," which didn't mean she was arrogant. It meant that she had this attitude, which is, I have to make a decision, I will make a decision, and then if I'm wrong, I'll fix it later.
Yeah.
She was willing to go back and reconsider.
So I'm sure you have some thoughts about Bush v. Gore, Ted.
When was that? Well, I think I'll just say a couple of things. I wasn't there, in the chambers, and nobody else was, and we have these notes and so forth. So people are reconstructing things and what people have said afterwards about what happened and the dynamics and so forth. I'll say this about the court. We did go there twice. It was shortly after Thanksgiving, we filed the first cert petition, and that was to complain about the fact that the courts in Florida seemed to be changing the rules that had been adopted by the legislature, and the Constitution puts this squarely in the hands of the legislature. And I'm not trying to re-argue the case, but that was our angle to get to the Supreme Court. Most people thought they're not going to touch this, and Justice O'Connor has famously said to her brother or son or something, we'll never take that. That's a state court thing. So when we filed that cert petition, we were very much concerned about what was going on in the courts in Florida, and we had no way out. I mean, we were on a squeeze. The votes were changing, the counting was changing, the rules were changing, and so forth, and we really had to get someplace out of the Florida court system. So we filed this cert petition. I think it was the day before Thanksgiving, and they took the case the day after Thanksgiving, I think it was, and then we argued. It was Bush versus Palm Beach County, as you said, and we argued the case to the Supreme Court, I think it was December 1st. Yep. And our position was that the rules are being changed down there. There's no clear understanding in the Florida courts that they have to comply with the federal statute that sets timetables and certain restrictions on how votes can be counted and so forth. And you've got to do something about this because the rules keep changing every minute. And we argued that case on December 1st, if I'm right, and they decided it on December 4th.
Yeah, that was a really quick turnaround because they basically said, go back and just get it right.
They sent it back to the Florida Supreme Court saying, could you explain what the hell you're doing down there? I mean, that's a short form of what they said. That was, as I said, December 4th. I argued the same case again in the 11th Circuit, en banc on that was a Monday. Then it was on a Wednesday. I argued in the 11th Circuit, and then on Friday, on the 8th of December, the Florida Supreme Court issued another opinion, and this time changing the rules yet again. Now this is the Friday afternoon on the 8th of December, and they ordered a statewide recount. Again, just from my perspective, we thought, what are they doing down there, and how can this be done before the statutory deadline, and so forth. So that was an afternoon decision. We filed a petition for a stay and asked that the stay petition be treated as a cert petition. By 8 o'clock that night, we got it on file in 5 hours. And then Saturday, in the middle of the day, they granted the cert petition, granted the stay application, treated it as a cert petition, set the case for argument. That was the 9th, and set it for argument on the 11th, requiring us to file 50-page printed briefs on Sunday.
Wow.
The next 24 hours later, which we managed to do. The other side managed to do that also. And then we had an argument on Monday, the 11th, and they decided it on the 12th.
That's right.
So the justices were working under enormous pressure. They could be criticized. Might criticize the court or the individual justices for even taking the case or deciding it the way they decided it, but they were working under enormous pressure, and I give all of them credit. They were all conscientious about what they were trying to do. But in the history of the United States Supreme Court, that first decision in 10 days from taking the case to the decision, it was a record. They've never, ever done anything like that in a significant case. That 10-day record was broken the second time around when they did it all in 4 days. So my compliments, and I felt, of course, I liked the outcome, but the justices were doing the best they could with a difficult circumstance under impossible deadlines, because that December 12th day was a very important day in the federal statutes. They sort of had an obligation to get it decided at that point.
All right, I'm having a little bit of agita. We're hoping that we don't have to break that record again this season. But so, Judge Rao, you came to the court as a clerk right after all of this, right? So talk about that experience and how meeting and getting to know these justices after that, when, you know, so much attention, there was a public attention shift, a public opinion shift about the court during that time. How did the justice handle that, and what was it like being a clerk right after Bush v. Gore?
Yeah, I have to say, so I clerked the 01 term right after Bush v. Gore, and we were all of us who clerked that term were incredibly grateful that we had not been there the year before. And but I have to say, you know, the way that the law clerks cycle into the Supreme Court, it's sort of on a rolling basis. So at some point, you know, when I started, there were maybe still half of the clerks from the previous term. And what was quite clear is that many of the clerks from the previous term really had a lot of animosity, I think, from the wake of Bush v. Gore. And you could see that in the email traffic, and it was not very nice. But I was also struck by the fact that the justices really seemed to have completely moved on from it, you know. And I know, talking to Justice Thomas and talking to some of the other justices over our lunches, like, you know, it had been in a very, you know, this compressed and very difficult decision. But the justices, you know, I guess being older and more mature and, you know, consistent with their role, had, you know, it seemed like between the justices, the relationships were generally fine. The law clerks still harbored a lot of animosity.
That's interesting.
After Bush v. Gore, and it just sort of redoubled our resolve to not have that type of term.
So talk a little bit more about the relationship that you got to have with Justice O'Connor behind the scenes, because nobody sees this. We only see their opinions, especially during that time. I think some of the justices now speak publicly a little bit more, some more than others. But at that time, they really spoke with their opinions, but you got to see who she was. We were chatting about this a little bit before.
Yeah, it's one of the great joys of clerking, that you do get to see the justices in a more personal way, at least a little bit. And I had the pleasure of doing weekly yoga with Justice O'Connor. She was a big fitness buff. Yeah. Oh, there you go. Yes, that's right. Yeah. So she would, Justice O'Connor brought a yoga instructor in once a week, and also an aerobics instructor several times. And she would invite any of the female clerks in the building to join her. My term, I was the only clerk, I'm not sure why, who decided to join the yoga class. But it gave me just an opportunity every week to, you know, to see the justice and to speak with her about all kinds of things. Some of her friends would join in the class, and so I got to see sort of this human side of Justice O'Connor. And I was looking at her book, The Lazy Bee, about the ranch, and she had inscribed to me, she said, Dear Naomi, she had written some things, and also, keep exercising, with an exclamation mark. And so I think that was pretty great. I have to say, I also remember a time when I was a law clerk. All the law clerks received an email message saying, all law clerks meet in the West Conference Room. Justice O'Connor, was calling a meeting, and we were like, why are we going to the West Conference Room? And so, of course, we all marched down there, and she has brought in a barbershop quartet to just play for us that afternoon. And I'm not sure what was the occasion for this, but she just brought in and it was so charming and so lovely and so kind, really. And so, I don't know, I have a lot of very fond memories of her and how she was not just with her own clerks, but with all of the law clerks.
Yeah. So that's wonderful. I want to talk a little bit more about her role as a centrist or a swing vote or a consensus builder. Since covering the court, there have been different justices that were labeled that. How true was that? I mean, I remember for me, I know a lot of law students right now, I don't know how they're doing it with the quick change of pace of the law, but when I was in law school, we were still trying to figure out the repercussions of Casey and the change on the abortion decision. That opinion was written by 3 justices together, including O'Connor, sort of not overturning Roe, but sort of clarifying it. Julia, what do we learn from Justice O'Connor and her approach to jurisprudence as we look back on Casey now, all these years later and after Dobbs?
Well, I think she was a true conservative in the sense that her decision-making was the common law method. She believed in deciding each case on the merits. By the way, she didn't think of herself as the 5th vote. She thought of each vote on each case being important, right? And she wasn't looking to be the swing vote. She often said that. She viewed it as an incrementalist approach, that you end up with the right answer by taking each case and incrementally deciding it. Justice Scalia was, the jump forward, come up with an overarching theory, and then work it out as you go on. They're both legitimate approaches, but hers was very, in a sense, I think, conservative. The current court, they're very radical in their willingness to, for example, I think they've probably overturned more cases more rapidly than, say, even the Warren Court, which was pretty radical as well. But I think that her approach was very incremental, very on the facts, very what is this case going to mean to these litigants and also to other people who need an answer. So what she would do, for example, I remember writing one concurring opinion in an affirmative action case. And the court was hopelessly splintered, different opinions. And it was really hard for people on the ground, let alone lower court judges, to figure out what do we do with this mess. And she wanted an opinion that basically said there are 5 votes for this, so that going forward, take this as a way to do things. It was very practical and very intentional in terms of providing actual. And I think she did this in a lot of cases, trying to provide a roadmap for lower courts and for people on the ground.
Kimberly, just to add a PS to the, we're talking about the 1992 Planned Parenthood versus Casey, which reinforced Roe v. Wade from 1973, and which is now since, of course, been overturned. But there was a 1989 case that I recently went through the archive to see what was in there, because that was an abortion case called Webster out of Missouri, where Justice O'Connor, up to that point in 1989, had been voting to uphold abortion regulations. She had basically been with the conservative wing anti-abortion rights. And Justice Blackmun, I see one of his former clerks here, 1992, Justice Blackmun was really uneasy with where Justice O'Connor was. But it was in that 1989 Webster case I saw through her documentation that we really see frankly, the Scalia effect on her abortion jurisprudence. The more he pushed, the more Chief Justice William Rehnquist pushed, the more she started to edge over, and this 1989 Webster case kind of got her moving slightly toward where she ends up in 1992 in Planned Parenthood versus Casey. And I think one lesson I took from that, again, just really seeing how she worked with her colleagues, was also she could be a third or fourth vote when she was dissenting against abortion rights, but when she became a potential key vote to reverse significant precedent, she did not want to reverse significant precedent. And that's when she joined, of course, with David Souter and Anthony Kennedy, who also had evolved, so to speak, to uphold Roe v. Wade in 1992 with Casey.
That's really remarkable to think that you had 3 Republican-appointed justices who formed that consensus in Casey, just creating the undue burden standard, but letting Roe stand. In that evolution, Ted, how did that affect how you approached arguing before the court? Did you see, what ways did you see Justice O'Connor evolving in her jurisprudence over time?
Every time I argued before the Supreme Court, I would and with my colleagues at my law firm, I asked them to prepare 2 or 3 of the younger people, everybody's younger than me, to prepare an analysis of how each justice would look at the issues in that case. And as you know, many of these cases have more than one issue. It might be preemption, it might be states' rights, it might be Commerce Clause. There's all kinds of issues. I'd wanted each justice to be analyzed, what they've written, what they've said in argument, where they come from, where their background is, to try to analyze every single justice as if there were 9 Supreme Courts out there, and there really are. It isn't one Supreme Court. So I would want each justice to be analyzed and a prediction made as to how the justice is going to rule on each of the issues in this case. And then I would promise them a free dinner or something like that if they got it right. Of course, we always had a free dinner, and no matter what win or lose. But with Justice O'Connor, it was very, very important to understand and really study the record of the case, because she knew that record backwards and forwards, and every little thing in that record, you'd better know that record. And she was often the first justice to ask a question during oral argument. And you'd better be ready. I was tried to be ready. You couldn't always anticipate what the question was going to be, but sometimes it was about something in the record or something there, and you had better have read all that stuff. One of the earliest cases I ever argued in the Supreme Court, it had to do with punitive damages, and we had one of the people that worked for me said, you'd better think about that footnote 5 in this other case, because that footnote 5 cites lower court opinions about whether a court should take the case or not in the Supreme Court, and so forth. And so we prepared the analysis of the cases that were cited in footnote 5 of that previous case. And sure enough, the very first question, she said, "Well, Mr. Olson," and she was, I was very polite and cordial but tough, and you better know, what you were talking about, because she would probe pretty far and make you look pretty stupid if you give some, not that it was hard to look stupid, but she said, "Now, Mr. Olson, what about footnote 5 in the such and such case?" And I was able to say, well, those cases that are cited in footnote 5 can be explained in this way. And one of my colleagues said, "How did you do that?" But the reason I did it is because we anticipated that she would be prepared, meticulously prepared, and would ask some question that was important from the record or important from the jurisprudence. And she did that over and over again. Frequently, she was the first one, and if you could anticipate that, help you a little bit to get things going, because it's changed now, but in those days it was a half an hour per side and they were all peppering you with questions, interrupting one another, and you had to be on your toes, and you had to understand when you heard a voice, you might be looking this way. If you heard a voice at the other end, of course, she's the only woman on the court, so it wasn't hard to figure out that that was Justice O'Connor. But you had to know this is a justice going to ask this kind of a question and be ready for it.
Julie, you must have been exhausted with that much focus on the record being
Well,
a clerk.
also they were hearing 150 cases a term at the time. Now they're hearing about, what, 70, 75?
If that.
Yeah, so
59 last term.
yeah, so we kind of we were briefing all those cases as well as doing the cert pool, and so it was a lot of work. I will say that she was a very hard worker, but also incredibly disciplined. She'd show up for exercise class, she'd take her shower, she'd work all day, and then she'd go out with John dancing, or go to the National Gallery, or do something that had something to do with culture in D.C. She loved music. And somehow, I don't know how she did it, she was so disciplined about her life, including that there was exercise, there was socializing, there were arts involved. And she lived her life that way. I don't know how she read those records.
That's incredible.
Right?
That makes me feel like a slacker. Just
There you go.
listening to you
We all
describe
did.
this.
I need more dancing in my life.
We went whitewater rafting.
Oh my goodness. Well, Judge O, part of the reason that they were able to do 100 or more decisions in a term, I mean, I remember when I first started covering the court, there were arguments in the morning, and then there was a lunch break that we really didn't get, because by the time we got back down and then we had to line back up, it was maybe 15 minutes. So I learned to take a granola bar or something and eat it in between. And then there'd be 2 more arguments. There were multiple arguments during the day, but having that kind of productivity requires the justices to work well together. And I this is just my opinion. I'm an opinion columnist. I'm wondering if the 59 decisions mean they're not working so well together. Talk a little bit about the ability to come together and work with that kind of efficiency on these big cases. I mean, we're talking about some of them, but that's a lot to do. A lot of bankruptcy cases, administrative law, it's a lot going on there.
Well, I mean, it is interesting. I mean, in terms of, now they're hearing about 60 cases. Is that really so many? I don't know. But it's about the number of cases I hear every year. And I guess I do feel like I'm pretty busy. But, it's, I don't know, judging is a very collegial activity at the appellate level, right? Whether it's the Court of Appeals or the Supreme Court. And, watching the justices work together, at least the term that I clerked, I felt like there was a lot of collegiality between the justices and a lot of respect for people's, independent views. And, there was obviously attempts to persuade, but also, at least I think, from Justice Thomas's perspective, he always sort of, he made his case and then he sort of stood down, and I think there's something I learned from that, in my current job. And, how do you work with people who are all basically have the same rank, the same number of votes, over what may be, 10 or 20 or 30 or 40 years together. That sort of repeat engagement is a very unusual kind of job. Yeah. And so I do think being a clerk and watching that in practice was really helpful for me in my current job.
So, and I'm going to start with Joan here. One thing that Justice O'Connor wrote that I have returned to a lot over the past year or so in trying to analyze or 2 years, in trying to think, well, what did she really mean by that, is this one. We expect that in 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. That was Justice O'Connor in her opinion in Grutter v. Bollinger in 2003. Of course, the Supreme Court has since overturned that case, and affirmative action is no longer allowed in our universities. So, Joan, was that dicta? Was that an expression of hope? Or was that a deadline? What do you think?
Well, first of all, there is always a Sandra Day O'Connor comment for that, or quote for that. There's always something that she said that is meaningful for our times. And that was in, and certainly just to orient everyone, when the Grutter decision that Kimberly is referring to, the 2003 decision where they upheld racial affirmative action at the University of Michigan, when it returned to the justices, not 25 years later, more like 20 years later, the Chief Justice felt that that was a deadline, as he wrote in Students for Fair Admissions versus Harvard. I actually think it was more aspirational, just from looking at the papers. You know, I'm definitely not gonna quibble with the majority of the Supreme Court today. But if you go back and you look at the record and you look at what her papers in Grutter aren't available yet, because her papers cut off when Justice Clarence Thomas came on, because he's still sitting. But Justice Stevens's papers are available, and Justice Stevens wrote extensively about it, and her law clerks have talked about it. And that law clerk class from 02-03 is a really powerful law clerk class that I've written about too, because they had that, and you referred earlier to the sodomy case that then gets reversed in Lawrence of that year. So it was a really important year, and it was frankly in some ways the last gasp of liberalism that year. But just from my amateur position and looking at the documents, it looks like that was aspirational, but hey, the chief got 5 votes to reverse it and to say it was a deadline.
Julie, I heard you chime in. I think you have thoughts.
I worked on an affirmative action case early on, and we had some.
Was that Adirond, or no?
Yeah. But it was I'm not going to go into it because I'm speaking out of school. All I can say is we had some spirited discussions on the issue. She was deeply committed, I think, to racial justice. She was wondering what the court's role in that was. I think what she was really persuaded by in the later cases were the briefs from government officials and from business and from the military, saying that this is not just an issue, this is an issue for everybody, that society as a whole is much better if we have diversity. And that made a huge impression on her. And I think, so I do think it was aspirational, and I do think that, I'm not going to make a forecast about how she would have voted.
Well, that's interesting, because in that case, the compelling interest was diversity. As you said, diversity in classrooms is good for everyone. It wasn't in leveling the playing field. That wasn't the compelling interest. It had to benefit everyone, and that sort of was it. It wasn't
a disadvantage for people. It was an effort to make everybody advantaged through this societal commitment. That's the way I saw it. And that's the way she expressed it.
So in terms of, it's interesting to me thinking about this now, looking at it, from the point of it being overturned, is how conservatives who had very conservative ideologies were looking at this, trying to figure out the court's role. But at the same time, you have a justice who herself faced discrimination. She faced the fact that she graduated from law school and couldn't get a job at a law firm. I believe she was turned down by some 40 firms before she had a job as a legal secretary, and then eventually went into politics in Arizona instead, but still having this conservative ideology.
She hired more black clerks than most of the justices. She hired a clerk who had physical disabilities so that she could only move one finger. She hired a blind clerk. She really reached out, and it was important to her.
Yeah. Well, just sort of help us understand how somebody who has, is clearly
she was really worried about this idea.
She's complex.
She wanted equal protection to mean equal protection. Okay. It's a lot easier, right, to say we need to treat everybody equally. That's the rule, and we'll work on other things to make sure society is fairly diverse. Right.
Is that sort of how you saw her equal protection approach?
Well, I think the case we're talking about is very complicated. There were 2 cases. One was from the University of Michigan, and one was from the University of Michigan Law School. Those 2 programs that were designed to promote diversity in the student body were designed by the same Board of Regents, the University of Michigan Board of Regents. The court struck down, upheld the law school program, and struck down the University of Michigan program. I was a Solicitor General at the time, and we had some tussles in the administration about what the briefs should look like. I wanted to take the position, a hard position, that diversity, standing alone, is not a compelling governmental interest, and try to win the case on narrowly tailored and that sort of thing. But to get rid of this compelling governmental interest, the idea that diversity, now right or wrong, I'm just saying what we were trying to argue. We were talked out of that by someone who had a much higher position in the government than me. No, you can speculate as to all the people that were higher than the Solicitor General. So we did not take that position, and I was arguing at the time, if we don't take a hard line on compelling governmental interest and diversity, we're going to lose Justice O'Connor, because we can't, if the government's not willing to take that position, she's not going to be willing to take that position. So the decision came down, and it was, I think, 5-4 in both cases. 5-4 striking one down, 5-4 upholding the other program designed by the same Board of Regents to accomplish the same kind of thing. And Justice O'Connor, I think, was the only vote on the winning vote on both sides. I may be wrong about that, but then I accumulated, not just then but subsequently, that starting with Bakke in 76 or 77, the counting the number of opinions written by justices on affirmative action. And I came up with something like 28, 29 different opinions, majority opinions, concurring opinions, dissenting opinions, concurring in the judgment and dissenting in part and concurring and so forth. But 26, 27, and Justice Scalia, I think in one of the dissenting opinions said, if we can't come together on what this issue is and what the jurisprudence should be, how should a school board or a Board of Regents figure out what the law of the Constitution requires? So it's all over the place. And that's been very difficult. They made this other decision in the Harvard, North Carolina case this time. But the justices, all of whom I think are struggling with the same thing that everybody does. We want to be the equal treatment for everyone. On the other hand, we want to recognize that our history is not the kind of history that we should feel proud about. And there has to be some consideration taken into account of the benefit of people coming together and from different backgrounds and different. So how do you reconcile those two? The court really is still going to be grappling with that.
I want to wrap up our discussion before, if you still, in maybe 10 minutes or so, we'll turn it over to questions. But I want to talk about what Justice O'Connor did once she left the court and what we learned from that. She's one of the few justices who retired and still had the ability to do more. And she focused very much on a few things. The first is civics education. I was really taken by how she really dedicated a great deal of time in wanting the American people to understand better how the court works and how the judicial branches, state and federal judicial branches work more, which I think is terribly needed still. I think there's a little bit more interest because it's in the headlines. But Joan, tell us a little bit more about this civics education drive. Where did that come from?
Well, I think she realized that people, even the basics of the three branches, she was discovering that this just was not being taught in schools the way it needed to be taught. So she took it upon herself, and this was part of her, she's a problem solver. She was a problem solver. So basically from January 2006, when she stepped down, to, I would say, roughly 2012, 2013, she was very active in iCivics, and that's still going very, very strong, and Justices Sotomayor and Neil Gorsuch have both helped pick that up through the years, as have other colleagues. And I think it was thinking, let's start at the let's start at the ground floor and try to get people engaged in how government works, because if they don't know how government works, they're not going to understand how the Supreme Court itself should work. And then one other thing she did, she loved to travel abroad, which I think everybody here knows how much she loved to travel abroad. But she was, during her time and Justice Kennedy's time on the court, they did a lot through the overseas program of helping the Eastern European countries write their constitutions. So she had kept up a lot of international travel too. And occasionally I would cross paths with her, and she would say two things. First of all, she said, well, if it isn't my author. And she would always, she would, one time she even asked, I know, I had too good of an imitation of her. But anyway, she once asked how sales were, which were nothing compared to the Lazy Bee or anything. I was not cutting into anything she had done. But the other time I ran into her after one of her really long, and she just really did not stop. Yeah. And she did at one point say, I'm just getting tired. But she didn't until the very end. And she sat on cases. One other thing to remind people about is, and we've seen some of the, certainly David Souter did, and I know Justice Breyer will, she sat on appeals court cases. So she just kept earning her government salary.
Yeah, you talked, you chimed in a little bit about her.
I was actually so Justice O'Connor threw a conference at Georgetown where I teach on the state of the judiciary, because she was very concerned about impeachment and elections influencing judging in a way that was inappropriate. And what we took away from the conference was that nobody valued judging because they really didn't understand what judges do. So I called her and I said, you should do an online civics book for grade school kids. And she said, great, do it and have it to me in 6 months, which was her answer to literally everything. So I brought a colleague up who had written an ebook. This is 2008. Nobody had books, and we showed her the ebook with like hyperlinks, and she turned to me and she said, "Julie, that's so clever. How did you think of that?" And I was like, "Well, just it was just an odd Tuesday. I came up with the idea of hyperlinks." But anyway. I was in charge of it for about 6 months, and then everybody realized how awful I was because I didn't know anything about civics, middle school teaching, or anything online. So we ended up hiring people, and it became a thing. She really believed in iCivics. She continually went around the country and said it was the most important thing she had ever done. She viewed it as her legacy project, and I am very proud to say, if you look it up online, it is a booming organization that her family is vehemently supporting, as are the clerks, the former clerks. And it's really a worthwhile thing, and it was very much intended to be a non-political, right, but games-based learning experience. So kids would, it's called adventure-based, I'm sorry, I'm talking to you. But adventure-based learning, you engage in the game, and you want to win, and so you learn what you need to learn to win. And that was the thesis behind it. Now it's available in Spanish, and it's truly a testament to who Justice O'Connor is. So that's my pitch.
And that was remarkable. And it was also remarkable, as you brought up, her advocacy for not having elected judges, which I thought was really remarkable, because usually justices, when they're on the court and even when they're off, they don't really take positions in that way. I mean, yes, we've seen Justice Breyer writing about democracy and stuff, but she was really taking a position that judges should not be elected, that that is a problem for our democracy. Talk a little bit more about that. Where do you think that I mean, we already know she had the confidence and knew if there was a problem, she wasn't afraid to solve it. But talk about her taking that up as an issue too.
Well, I met with her shortly after she resigned. She asked me to come and be a part of a steering committee of what am I going to do now. I think that, well, not that I was going to tell her what to do, but she wanted some help from the outside world. I don't think other people could talk about this, but she wasn't completely happy with not being on the court. She was an active person and a decisive person and a make things happen person, and now she wasn't on the court anymore, and there's all sorts of stories that you might ask about that. But then she wanted the three things that she talked to me about, and we raised some money for her. We raised about it was maybe a couple $1 million to help her do civics, civility, and judicial independence. Now, so the election of judges bothered her a lot because she was concerned about the image of judges and felt that electing judges made judges politicians and that made people not believe in the integrity of the judicial decision. And there was a case that I argued later on involving money that went to a Chief Justice in West Virginia, and that was a very signal case in that. But that was very, very important to her. She felt that the American people had to understand civics, because if they didn't understand civics and the way our government worked, then they wouldn't respect properly and the way our framers intended the role of a judge, and a role of a judge to make hard decisions. And also because of the kind of person she was, the relationship between herself and her colleagues, and the relationship, she wanted people to feel, to understand that the Supreme Court justices were making decisions, that they were working together, whether they agreed in the opinions or not. But that was all of what she was trying to do. And she threw herself into this. And at the same time, she was going around from Court of Appeals to Court of Appeals, participating in decisions. You can imagine all of a sudden Justice O'Connor drops in on the,
Could you imagine?
on the Ninth Circuit.
Terrific.
But she loved to do it. She was a judge, and she always wanted to be a judge. But she also wanted to have an impact, and an impact that went beyond her tenure on the Supreme Court.
So before we turn to questions, I just want to end on one question. I'll start with Joan, but I want anybody to jump in as well. Without talking about exactly, specific cases or anything, what do you think, knowing everything that you know about Justice O'Connor, she would think about the declining trust in the court as an institution? She clearly cared and wanted people to understand how the courts work, to have faith in justices, to have faith in what they do. The fact that polls are showing that that is slipping, what do you think she would think of that, Jim?
Well, I think she'd be disheartened by it. I think there's no question. She wanted the court to have respect, and I think she would not like that the court has that the public approval is in so many polls show that it has plummeted. But oddly, I was in a position, Kimberly, to once ask her on stage after she had left what she thought about what was happening at the court in terms of, how some of her rulings were being reversed. And it was down at William and Mary. There were a bunch of us for a Supreme Court preview, and she had a relationship with William and Mary because of former Chief Justice Berger. And it was right after Justice Alito had become the swing vote as her successor on a handful of cases that went the other way. And, I said in sort of a timid way, well, what do you think about what's happening up there? And she goes, well, how would you think? What would you think if they were dismantling your opinions? So,
she said that a lot.
Yeah. So, she was not, she would say what she thought, even if you went into it sort of ready to be slapped back by her. But the point was that she would be saying, she'd be a reality check, I think. I think she'd be a reality check to say, look, the public has to have confidence in the courts, and we know that polls are showing that, Republicans have more confidence in the courts right now than Democrats, but overall, taken as a whole, it's now slipped. I think the Pew Center survey most recently said slipped below 47% approval rating. So, there's no sugarcoating that, and the last person to sugarcoat anything would be Justice O'Connor.
Yeah, she was very vocal about that. She was very unhappy about those things. I also think she'd be deeply disturbed about the decline of stare decisis. She's a traditionalist. She was a conservative. I remember a couple of cases where she voted against how she would have voted had there not been an important stare decisis component to the case. And stare decisis means already decided. In other words, the court operates on the principle that people should be able to plan, that there should be stability in the law, that you can't just be changing the rules all the time. and that's important as a societal matter. It's important as a business matter. It's important for a lot of reasons. And she deeply believed in that. And I think she would have been very, very disturbed by how quickly the court is reversing major precedents.
Anyone else? Go ahead.
Yeah. So, well, I mean, I'm a sitting judge, so of course I think the legitimacy and integrity of the courts is extremely important. But I do think we have to think about why the approval rating is going down. And is it because the court is not doing its job, or because people are upset with the outcomes? I mean, I think those are two different things. And I do think as a judge, I mean, part of judicial independence is, you try to find the right answer to cases. And so a lot of critiques, I think, from commentators in the media about what the court is doing is about the outcomes. And I do think in part understanding the legitimacy of the courts and preserving its independence requires looking at how they're going about their decisions, what kind of reasons they're giving. And I see a lot less commentary about that. So if the crisis of confidence is just about the outcomes rather than the legal work itself, then I think that's just something probably the court has to live with.
You get the last word before questions, Ted.
Well, I will only say one thing because I know that there are questions out there. It's very, very important to me personally, as a person who practiced law for a long, long time, and who's appeared before the court, to have the court respected and the individual justices respected for the decisions that they make. And I find dismaying that the sense of the public about the court, I think, is wrong, and it's disappointing and not helpful to our society and our democracy and our Constitution. One of the things I have to mention is that some of the fault lies in the United States Senate. Justice O'Connor was confirmed unanimously. Justice Scalia was confirmed unanimously. Justice Kennedy was confirmed unanimously. In the days up until the Bork stuff and the Thomas stuff, the justices were being confirmed. If they were properly credentialed, and they virtually all were, there were maybe an average of 3 negative votes in the Senate in their confirmation process. In recent days, the last few years, and all of these persons have been nominated, were extremely well qualified. They went to the finest law schools. They had appeared they had sat on courts of appeals. Their credentials were stellar, all of that stuff. The average number of negative votes in the Senate is something between 45 and 47. So that's the government of the United States and the Senate saying to the American people, this person who we're about to put on the highest court of the land is not qualified, or is a bad person, or is someone who won't render fair decision. So when we go through that, they have to go through at least a week and maybe more of this confirmation process where the one side says nice things about them, and then the next side says awful things about them, and then back and forth. But the American people are seeing that, and then that has got to have an effect on their respect for the institution once these people that have been savaged in the United States Senate are now on the highest court.
Okay, I know you guys have a lot of questions. Please wait for the microphone before you ask them. Raise your hands, and we will try to get to as many. So over here, we'll start.
Thank you very much. This has been extremely enlightening. I'm curious, did Justice O'Connor, what she thought about oral argument, the impact that it had, and also, did she ever recuse herself from a case?
I know the answer. I know the answer, only because I've been going through.
Joan knows the answer to everything, by the way.
I know.
We defer.
Justice O'Connor, don't ask me about any of the current ones. No, she did recuse, and in fact, for anybody who's a lawyer in this room, the Chevron case was on people's mind. This was a case on regulatory power that recently was reversed by the current Supreme Court. And in going back through those papers, I had known that she had sat out that case, but I didn't know why. And in the documents, she sat out at the very last minute because she found out that her father had just passed away and part of his estate was tied up in one of the oil companies. So she sat out. And that case actually was decided by the bare minimum of 6 justices because others sat out. So she did recuse. She did recuse sometimes for financial reasons. I don't think, because she didn't come from a lower federal court like Judge Rao, she came from a, state court and state legislature. She didn't have any grounds to recuse from prior work. And I think she ensured, and I'm pretty sure, her husband John, who came to town as a lawyer, did not practice in the Supreme Court sphere, so she wouldn't have to recuse for those reasons. But she did on occasion, but they were specific reasons like that.
How did she think about oral arguments?
Well, she wanted a full briefing memo, which is a summary of both briefs. You had to read all the cases to make sure the parties presented the cases appropriately. And you had to pose questions for her. She asked her own questions. She didn't care about our questions, but it gave us it was an exercise. So she prepared very carefully. She read the record, one of the few justices who did. And she would start with counsel, and then she'd follow with, "You have not answered my question."
That wasn't happening.
No, I'm sure it wasn't. I think my sense was, and I can't speak definitively, but my sense was she thought people could lose at oral argument, but they rarely necessarily won. You could concede too much, but generally the cases were decided on the briefs. And sometimes I think when it got later on, where the justices were making points for each other's edification, a lot of times the oral argument descended into a conversation among the justices who were actually having conversations with each other by the way they phrased questions. Is that fair?
Yes.
That must have been annoying.
If you say so, yes.
Anybody else have a question over here? The mic's making its way to you.
So we obviously have a difference of opinion. Let's say Judge Rao and Ted Olson will say, you look at them from Harvard, Yale, and they did well, and they're qualified. And then you look at what happened in the abortion decision, and a justice looks and says, is there a history of abortion rights in the United States when women were property? Mm-hmm. And if you want to take that approach, you predetermined how the case is going to come out. Personally, I think that's outrageous. And the reason there's a lack of respect for the court is not so much the process, it's the decisions that come out of it. You can't get away from that. It doesn't matter what the discussion was in the Senate. When the opinion comes out, that's what counts.
So what's your question?
I'd like a reaction to that.
Well, I'll say this. Over the history of the Supreme Court, there have been periods when the court has been very unpopular. They were sufficiently unpopular that Franklin Roosevelt wanted to change the number of justices on the Supreme Court because they kept striking down his program, New Deal administration. During the Warren era, there was a lot of unpopular opinions out there of the justices. I grew up in California, and I remember seeing billboards saying impeach Earl Warren. So there have been times, and so people, when I like to think that, I do think that the court deals all the time with very difficult decisions about which people feel strongly. They are about abortion, they are the death penalty, they're the freedom of speech, the freedom of religion, the right to vote. All of those things matter to all of us. There's going to be a winner and a loser in every single one of those cases. During the term, they're usually 20, 30, 40% unanimous in cases, but you never read about those cases. The ones that you read about or hear about are the very, very controversial cases. There are people who do not like the decisions that and I gather from what you're saying that you might be one of them. Don't like what the court has been deciding in recent years, and there are people that I know that didn't like the Roe versus Wade decision, or I could go on and on. But that makes the potential for the court to be unpopular, because it's a public issue that's vital to all of us, and there are winners and losers, and the losers are going to see, well, they're not going to say, in many cases, they're not going to say, well, I guess the reasoning that I thought was right was really wrong. That's probably fine. What they're going to say is those justices made the wrong decision for the wrong reasons, and therefore I don't like them.
Well, I do think it's fair to say that judicial philosophy is different. That originalism didn't exist when I was clerking, so I didn't have a problem with it. I do think I'll talk to you afterwards about, I teach my students, I explain both sides, and then say my answer is whoever gets 5, which I think you would agree with me on. But I do think to some extent the reliance on history, and to some extent cherry-picked history, can be work against the court in terms of its credibility. That's my personal belief, and I don't think we should ask the judge, would be my suggestion.
Well,
Go ahead.
I mean, I think most people agree that judges shouldn't be deciding cases based on their personal policy preferences. I think there would be probably wide agreement about that, certainly amongst judges. And then I do think there are differences of philosophy about how to approach cases and decide cases. And I guess I would just say, like, as a matter of civics or education or something like that, just because cases are hard and there are maybe a range of disagreements about what the right answer is, doesn't mean that the judges are acting in bad faith, or doing something that is other than part of their judicial role. And I think that sort of, that having that kind of respect for the courts is probably overall better for our society and our system of government.
Okay.
I'm a retired federal judge, and I wanted to share a couple quick observations about the justice and her colleagues based upon a trip. My husband has been active in the American Bar Association for many years, and we were privileged to attend the first visit the United States Supreme Court ever made to the European Courts of Justice, and this was the end of the 90s. And these are my quick venues of Justice O'Connor. We were on a bus for about 2 weeks going from place to place, and at one point Justice Breyer leans his chair back to rest, and Justice O'Connor came up behind him and hit the back of the thing. She said, "Get up. We want people to see we're working here," as if anybody in the countryside of France was looking. The second thing is I was in the ladies' room with Justice O'Connor and Ginsburg. And just as I was coming out, and Justice Ginsburg had these little gloves on, which she used to wear because she had, her hands got cold. And Justice O'Connor opens up her big purse and she said, "Ruth, you need to be taking this vitamin and this vitamin and this vitamin." And of course I waited. I was hid behind the stall and she was finished. The bus, she stopped the bus at which was a phone booth, and got everybody out of the bus to go sing to Justice Souter because it was his birthday. We're in the middle of nowhere. I mean, I don't know what was going on. And I forgot the last thing I was going to say. Anyway, huh? Pardon me? Oh, we were in Luxembourg at the palace or whatever it was, and Justice Kennedy got a phone call, or had to go take a phone call, and it was a death penalty issue. And he went into the phone booth, and I happened to be walking down the hall, and he came out and he was just soaked with tears. People don't see that side of the justices, that the toll that it takes. And she walked by and gave him a huge hug and sat there while he sobbed. Now all those vignettes made an impression on me a long time before I was a judge. But the one I wanted to end with was when we were a trip in Poland with her through Rowley. She was very active in the Rule of Law Initiative. And during that trip, we went to Auschwitz. And our daughter was with us. She was about 12 or 13 years old. Her name is Daly. And she took Daly's hand going into Auschwitz. And she said, Daly, you come with me. Walk through Auschwitz. And when it was over with, I was behind him. She said, Daly, don't worry. This will not happen in the United States. The Supreme Court will not allow it, and I'm on the Supreme Court.
Thank you for those. Thank you for those recollections. Does we have a time for one or two more questions? If we have some more, anyone have questions? Raise a hand. Okay.
Thank you all. So you spoke so beautifully about the justice's civics efforts. And about maybe she would have despair about what's going on now. She doesn't strike me as the despairing type. What would she be doing? What would she encourage her colleagues to do to change the narrative of what's going on in the courts? What would she be doing now for civics education?
She'd be out on the road, I can tell you that. I mean, because she did go out on the road a lot. And she also had, she really liked to play the game with the kids. She couldn't really play it, but she liked to be there when they played it. And you're right, she was a doer. She didn't want to just think about things. So I assume she'd be on the road. She was very, generally speaking, tactful about what she said, but as she got older, she got a little more out there. So I think she might have a few things to say, but in general, I think she'd be very concerned about the state of the court, and she would address that. She felt, when I interviewed, she asked me, and she asked every clerk, our cases are so hard. There are good arguments on both sides. You know, like, can you think of a single case where you think we were totally wrong? Because she really understood how difficult these cases were. Of course, I named a case that she was in the majority on. And she still hired me. So there you go.
Can I just ask a follow-up on that idea? Because I think one reason why the court's reputation is being harmed too is not just how they're coming out on their opinions, but how they govern themselves, and the lack of rules that govern them. She was very outspoken when it came to the fact that she didn't think that judges should be elected for that very reason. She didn't want people to think that they were being unduly influenced. So maybe, does anybody want to speak about how her views might have been on the issue of ethics, not just on how the court is ruling?
Well, there was one incident I learned about, and it was after Justice Scalia and the duck hunting deal, if anyone remembers from the early 2000s. You know, he had gone duck hunting with Dick Cheney, and then there was a case involving special Dick Cheney. Was it kind of a study group that they were working on? I forget what the group was. Yeah,
a FACA.
Yeah, the task force. Anyway, actually, was it your turn?
It was one I
It was. Oh, it was
Energy Task Force.
I was trying to remember which, if it was when you were doing. Anyway, you know, Justice Scalia had felt like, you know, he of course felt like he had done the right thing by not recusing himself from sitting. He sat on that case. And his colleagues had been mostly with him, at least according to him. And then there was so much public outcry that Justice O'Connor was one of the ones who had a bit of a confrontation with him that really kind of, you know, got his back up a bit, because she was concerned about the public outcry. And I think what she would do in these situations is she might not take that public, but she would want to talk to her fellow colleagues about, you know, we just really have to work hard to make sure we instill confidence through whatever we're doing. And the tale I tell, I've, you know, written about in my Scalia book, but I remember that he was a bit put off by the fact that she was sort of calling him out on it, but that was, again, something that she sort of could do, because they did have a very dear relationship at the same time that she could be critical of him. And, you know, he, as we all know, the way he handled that publicly then was, he did sit in the case, and then when he was, what was it, up in Amherst, when somebody gave him a hard time, he said, well, quack, quack. And that was that. That was Scalia. Oh, yeah, Scalia. We could do a whole panel on Scalia. Yeah, right.
We have a question from maybe one.
Everybody should read Joan's book on Scalia, too.
Yes, absolutely. One quick question we have time for. If anybody has one more quick question.
Final question?
So I just want to follow up on something Mr. Olson said, and I'd like if Judge Rao could take the lead on it, because you're a sitting judge now. I think, and I'm not interested in letting the Supreme Court off the hook for anything or whatever, anything like that, but I think Congress, to what extent has the inability of Congress legislatively to pass legislation on many of these issues put the Supreme Court in a position where they have to be an arbiter that they were not necessarily built to be in the first place? And as a judge, I'm just curious, because this probably is something that occurs to you. That's something I would just, how much of that is in the mix when we talk about how people look at the courts and their opinions?
Yeah, I think that's a great question because, I mean, the Constitution was designed to have 3 departments that vigorously exercise their powers. And the first branch of government, doesn't do very much legislating. And so there's a great amount of law and activity, and effectively lawmaking is done by the executive, and then it's reviewed by the courts. And I do think that has made a big difference. And some of these cases, especially statutory cases, would have perhaps lower stakes if, the Supreme Court is interpreting the law as they see it. Obviously, if Congress sees it differently, it just requires passing another law. But in a world in which there's little hope that Congress will do that, the stakes of what the Supreme Court is doing becomes much higher.
And a lot of the legislation out there is a dog's breakfast. So a dog's breakfast, like the obstructions chapter, makes no sense. So they're put in a very difficult position with the statutory interpretation cases, in my view.
Well, I would ask you to please join me in thanking our panel for this really enlightening discussion.
If we could just thank our amazing panel here for a great conversation. We will have some food and drinks in the back if you guys want to stay and discuss everything you heard. We want to thank again the Supreme Court Historical Society for their support of the event, our friends of the Library of Congress who are here tonight who really helped make this possible. And if you guys are interested, if you're not a friend and interested in getting more involved, we have information outside. It really helps make events like this and public events and really brings the collections to life. So thank you, everybody. Thank you to our panel. And thanks.